please the court. Westport requests in its appeal to reverse the grant of summary judgment in favor of defendant Howard Tate and the denial of Westport's partial motion for summary judgment. There are three primary issues. One is that the trial court erred in finding a lack of standing, that Westport had lacked standing to bring its claims either as a direct legal malpractice claim or as a contractual or equitable subrogee. Second issue is that the trial court erred in finding no proximate cause in the underlying case. In other words, that a reasonable judge would not have dismissed the underlying case for lack of personal jurisdiction. And the third is the trial court erred in finding no facts to support the claim of negligent misrepresentation. And we'd ask that this court reverse the trial court on those issues. And starting with the standing issue, Westport has brought its claim on a four-count complaint. Count one is for negligent misrepresentation. The standing argument does not apply to that count. It applies to the counts 2, 3, and 4, which allege a direct legal malpractice claim, a contractual subrogation claim based on legal malpractice, and an equitable subrogation claim based on legal malpractice. And the trial court's ruling found that Westport did not have standing to bring its claims because it did not have an attorney-client relationship with the Howard Tate firm. That's the wrong question. The right question is whether or not there was a duty between the law firm and the insurance company. And that's what the Stinson case from the Tennessee Supreme Court states. That's what the Collins case that follows Stinson. There's a whole progeny of cases that follow that a non-client can have standing to bring a legal malpractice claim against a lawyer if there is a duty established between them.
What is the duty here?
The duty is that a duty is created here between the law firm and the insurance company based on several things. One is that there's a reliance, that Howard Tate was hired by Westport. Westport paid Howard Tate. They had a long-standing relationship. They were panel counsel. Howard Tate agreed to abide by Westport's litigation guidelines that required Howard Tate to advise of impending deadlines, to consult on dispositive motions, to collaborate on the defense of the case. These are all assurances, promises, however you want to put it, that Howard Tate made to Westport and Westport relied on in engaging the firm and allowing the firm to defend its insureds over not only in this case but many others.
Well, you've just described the relationship between almost every insurance situation where an insurance company hires an attorney to represent an insured, haven't you?
Not necessarily. I think this case is different because of the guidelines. That stands out to me.
You're saying that that's not the situation normally?
I'm sorry, I'm not sure I understand.
Are you saying that normally that's not the situation where an insurance company provides counsel to an insured?
I'm not saying that a duty can exist in every case.
Well,
I'm saying that a duty exists in this case.
I'm struggling to understand the distinction here then.
I'm sorry?
I'm struggling to understand the difference or the distinction here.
Well,
let me make it simple, or try to make it simple. Who was the attorney's client?
The attorney's client was Brand's insurance agency.
So if there was a disagreement regarding strategy or whatever between what the insured wanted and what the insurance company wanted, what was required of the attorney representing the client?
It's provided for in the guidelines that if there's a disagreement or a conflict, that it's brought to the attention and that it's addressed.
So what controls there?
Sorry?
What controls?
I'm not sure.
How do you make the decision about who controls the litigation here?
Well, the controls, I'm tripping on that question, on that term. It was a collaborative undertaking.
If you've got an insured who says, I want you to do this, you've got an insurance company who says, I want you to do this, and you've got an attorney who's representing the insured, who does the attorney listen to?
Well, from what I've seen in the ethics opinions, and that this is a matter that's to be addressed between all three of them. It's a matter that's
Are you telling me the lawyer is not obligated to do what the insured tells him to do, his client? I think there's some ethical opinions out there that address that issue.
The insurance company, well, first, there's no conflict. There is no disagreement in this case.
These are the type questions I need answered, though.
Yeah, there's no disagreement in this case. The ethics opinions that I've seen that say when these issues come up, then they're discussed, they're addressed, and out in the open, and that's how it's handled. Tennessee is different from most states in that it doesn't recognize a tripartite relationship, which is three parties to the attorney-client relationship, but it does recognize that there are duties to non-clients, and that's the Stinson case, and that's its progeny, that there are duties to non-clients even though they're not in the attorney-client relationship. And that's what this case presents, is an insurance company hiring defense counsel to represent its insureds, relying on them and having guidelines that counsel provided an attorney suit report that's attorney-client privileged. It gives a full analysis. It's the only information that the insurance company is getting about the case. And so the factors exist here for the non-client for the lawyer to have a duty to that non-client.
So you're saying this is a different situation than every other situation where an insurance company hires counsel to represent its insured?
No, it's not different. But the facts in this case are such that a duty can clearly be found because of the guidelines, because of the promises, because of the assurances, because all the information that was being provided to the insurance company in this case. And because if you go the other way and you say there's no duty here, then you're disavowing Stinson, you're disavowing the restatement.
Has a restatement ever been adopted in this state?
It has in certain respects.
Has it in the respect that you're urging?
I haven't seen Section 51 adopted, which is one. The Arizona Supreme Court very clearly went through the application of the restatement with Section, I think it's 51 and then 134, dealing with the situation of insurance defense counsel, insurance companies, and the duties that exist between them. And it points to, in 51, that a duty exists between the insurance company and defense counsel in those situations, particularly where there's reliance.
Was there a contract between the insurance company and defense counsel?
There's not a contract, but there is an ongoing relationship.
There's nothing written, in other words.
Other than the litigation guidelines, I'm not aware of anything.
And they pay him if he obeys the litigation guidelines and provides the service.
They pay him to defend the insureds. Yeah.
And do the litigation guidelines include competent representation?
Well, the guidelines first call for the advising of any important deadlines, and the personal jurisdiction defense would be an important deadline because it's a threshold issue that's waived if it's not raised. It provides for giving analysis.
Were the guideline, did he violate the guidelines?
Did he violate the guidelines?
That's part of the guidelines are part of the agreement between the insurance company and this attorney, I thought you said.
Yeah, and I think they...
So if the guidelines get violated, wouldn't that give the insurance company the ability to go against the attorney?
On a contractual basis?
Yes.
Is that what you're asking? Potentially, but we're focusing more on a negligence basis and reliance basis.
I know you
and
are.
that the guidelines...
But I wondered if perhaps contract was ever brought up. Was it brought up?
We didn't frame it as a contract claim.
Okay, thank you.
Mr. Bruck, I'm afraid we took up most of your time, but we'll hear from you again on rebuttal.
Thank you.
Good afternoon, Ms. Roberts.
Good afternoon. May it please the court, Lauren Paxton Roberts on behalf of the defendant appellee, Howard Tate, Sowell, Wilson, Leathers, and Johnson, PLLC. Thank you, Your Honor. We are here today on a cross motion for summary judgment, a partial motion that was filed by the plaintiff, appellant, Westport, and the full motion for summary judgment filed by Howard Tate at the trial court level. As your honors know, that this is a de novo review with no presumption of correctness. However, we are asking the court here today to affirm the decision of the trial court for two primary reasons. The first of which is that Westport did not have standing to prosecute the legal malpractice claims asserted against Howard Tate, because Tennessee does not recognize subrogation of those claims. There was no attorney-client relationship between Westport and Howard Tate, and because Tennessee law prohibits the assignment of attorney malpractice claims. And secondly, and separately, even if Westport did have standing, Westport cannot meet its burden of proving a breach by Howard Tate that caused damages to Westport. This is important because we would be able to show, and we argue we can show, that a motion for motion to dismiss, Your Honor, on the personal jurisdiction issue, had it been raised in the underlying case in the trial court, it's the burden of Westport to show that that would have been granted by a reasonable judge, and that's the standard. A reasonable judge would have granted it. And Westport cannot make such a showing in this case.
Did the trial court make a finding about that?
The trial court did address the personal jurisdiction issue in the underlying case once Howard Tate was replaced as counsel by Frost Brown Todd, specifically Eric Rigner, who's an Indiana attorney. However, because it was not raised in an initial pleading, the trial court did not make any sort of finding on personal jurisdiction, whether it existed, didn't exist, or the factual issues. It simply addressed it from the standpoint of waiver. Your honors know.
No, I'm talking about this trial court.
This trial, yes.
Yeah.
In the underlying trial court in this case, Judge Ash did address it, and that we do think is persuasive to this court. Judge Ash is a reasonable judge, one would assume, and he found in ruling in the underlying case, in what has been appealed, he found in his order that personal jurisdiction did not exist.
Why is that not dispositive?
I believe it is dispositive, Your Honor. I think that that should be something that would be affirmed in this case.
Well, assuming Judge Ash made that finding that jurisdiction existed,
yes.
how can there be a malpractice claim if that's Judge Ash's finding?
I would argue that there should not be and cannot be a finding of malpractice by Howard Tate because of that finding. I believe that there are two bases for this court to affirm the decision by Judge Ash. Each of these stands independently in order to find that Howard Tate should be dismissed from the underlying case, from all the claims in the underlying case. By looking solely at either the standing or the legal malpractice claim, however, there is a fourth issue and fourth cause of action, and Judge Ash did issue a separate finding as to that fourth cause of action, that being the negligent misrepresentation claim. As to the negligent misrepresentation claim, I'll touch on that just briefly. But the trial court, Judge Ash found that there was no misrepresentation of any past or present fact, and thus he found that summary judgment was appropriate on that claim. One of the keys in this case is that there really are not many facts in dispute. And so because there are so few facts in dispute, and really the only facts that are in dispute are either not material or really simply an interpretive issue regarding statements. The statement itself is not in dispute that it was made. It was an interpretation between what Howard Tate asserted that statement meant versus what Westport asserted that statement meant. Because there aren't facts in dispute, that factual finding by Judge Ash should be something that's persuasive to this court, the factual finding that there were no past or present facts misrepresented. Turning to the two larger issues, the first being the standing issue that were just speaking about with my opposing counsel. As an initial matter, there's no dispute. Nothing has been asserted in any reasonable fashion that Westport and Howard Tate did not have an attorney-client relationship. Westport is the insurance company. It was not a client of Howard Tate. The client of Howard Tate in this case is obviously Brands, and Brands is not here before this court today. The 1995 case of Youngblood, which we cited in our brief, is dispositive of this issue. It answers this direct question stating the employment of an attorney by an insurer to represent the insured does not create the relationship of an attorney-client between the insurer and the attorney, nor does that employment necessarily impose upon the attorney any duty of loyalty to the insurer, which impairs the attorney-client relationship between the attorney and the insured, or impedes the performance of legal services for the insured by the attorney. Whether this is an accurate statement of the law in other states is something that should not be before this court today. It's the accurate statement of the law in the state of Tennessee. And obviously other states, Illinois being one of them, recognize this tripartite relationship between an insurance company, an attorney, and the insured who's being represented, and Tennessee does not. In one of the cases that's cited in the briefing, this National Union versus Dowd and Dowd case, an Illinois case that's discussing subrogation rights and legal malpractice claims, one of the statements made in this case is that there's actually a fiduciary duty between the attorney and the insurance company. And Tennessee specifically does not have such a relationship between the insurance company and an attorney representing the insured. And for that very reason alone, that National Union case is something that should be differentiated and should not be adopted by this court.
Well,
what is the relationship between the insurance company and the attorney?
It is, obviously there is a relationship between the insurance company and the attorney representing them, but it is not a relationship of the client to an attorney. It is the same as having somebody paying for certain expenses. You know, we all learned in first year of law school that if your mom comes in and pays your attorney's fees when you're a defendant in a criminal case, that the attorney represents you as the defendant in the criminal case, not your mom. And your mom can't decide how the case is being handled. And that's the situation, the same with an insurance company. Obviously, as opposing counsel.
So these guidelines that the insurance company has are not worth the paper they're written on?
Well, that's not the case, obviously. The guidelines, first of all, the guidelines don't say you have to consider and raise personal jurisdiction or report to us on personal jurisdiction. So that is something that is noteworthy for the guidelines specifically in this case. I mean, if you look at the guidelines are mostly a reporting requirement for the attorney to the insurance company as to the progress of the case and how the case is being prosecuted. It is not the overarching decision maker on how a case is
There's no
defended.
attorney-client privilege kind of stuff in that report?
Arguably, yes, there could be. However, I understand where Your Honor is going with that, but at the end
I
of the...
wish you'd explain it to me then, because I'm not sure, but go ahead.
I don't know, I guess I don't know what the ultimate place you're going is, but yes.
I'm just trying to learn.
Yes. It is a confusing relationship in many ways, but at the same time, the key to it is the duty of loyalty and the duty of confidentiality run to the client, the insured, in this case, Matt Brands and Brands Insurance. It was not a duty that ran to Westport.
So let me ask you a question.
Yes, sir.
In keeping with where Judge Bennett seems to be going. Let's suppose the attorney in this situation has a discussion with Brands, and Brands and the attorney come into possession of information that's important and about this case and relevant. But Brands says to the attorney, do not disclose this to the insurance company. What happens?
The duty runs to the client, and if I think that you could arguably, depending on what that information was and how that information could be used, you could create a situation where an attorney would have to withdraw from representation if it ran afoul somehow of certain things in that attorney guidelines, but...
And that was my next question. Even if that's inconsistent with what the guidelines say the attorney's supposed to do because the insurance company's paying his or her fee.
I mean, I think that creates a potential issue between the insured and the insurance company at the end of the day, but my understanding of Tennessee law is that the duty is from the attorney to the insured, to the client, and not to the insurance company as to in a fiduciary sense. I think Your Honors would agree that it's clear in Tennessee that under the Can Do Inc. versus Muneer-Herod case back from 1996 that you cannot assign malpractice claims, so Brands could not have assigned this malpractice claim to Westport or to any third party, and really that's what Can Do stands for, is this idea that malpractice claims should not become somehow currency where you can assign malpractice claims to somebody who can therefore go forward and collect on it instead of the actual client, the insured. And again, that puts the client relationship highest in Tennessee. I think that's apparent in the case law. And then finally, this issue regarding subrogation. And subrogation is something...
Before you get there,
yes, sir.
Let me ask you the question about...
Yes.
Opposing counsel says there are at least 2 Tennessee appellate court opinions that say this duty is created that runs to the insurance company.
Yes.
How do you deal with those cases?
I believe Stinson, the primary case that he cited, the Stinson v. Brand case, different brand, is can be differentiated easily from the case at hand. The Brands case deals with a real estate transaction, and ultimately what the court determined in that case, what the ultimate holding was, is that there's a unique relationship between the interests in a real estate transaction such that multiple parties could be considered to be represented parties by an attorney. It's a complex transaction and sort of runs along the lines of the same case law and thought process that our courts have held, that an attorney can represent multiple people in a real estate transaction depending on the the positions of those parties. And so one of the holdings of Stinson, in reaching that ultimate conclusion about this relationship that an attorney can be responsible to multiple people in Stinson v. Brand, is still the idea that an attorney is not generally liable for negligence to third parties who are not clients and are not in privity of contract with that attorney. And so for that reason, I think that the Stinson case can be differentiated. I don't know that I have the holding of the case that the opposing counsel is citing that builds on the Stinson case, but the Stinson case, I will say, to the extent that the second case addresses and opposing counsel believes it stands for the premise that there is a relationship here that would create the ability for Westport to sue Howard Tate for malpractice. That case is not, I don't think that case is on point. It's, I guess, Westchester v. Little, and that, again, is not dealing with an insurance company directly, and thus we think it's differentiated. It should be differentiated from the case at bar.
That was a situation where you were dealing with a guardian ad litem in a family case.
Thank you, Your Honor. That's right. And again, I believe that was the father trying to sue on behalf of his child, who was being represented by a guardian ad litem, if I recall correctly. Finally, the one issue I have not dealt with with regard to the standing of Westport's obviously the subrogation issue, and other courts in other states have found that subrogation of these types of claims is appropriate, but Tennessee is not one of those states. This would be a ruling of first impression in Tennessee, and I don't think that this is an area where Tennessee should expand the law and allow for this type of case to go forward. Again, for all of the various reasons related to Tennessee's jurisprudence on the fiduciary relationship between an attorney and their client, and not related to the insurer, unlike Illinois and other states. And if Your Honors have any questions, I apologize. I'm going over slightly. So
All right.
Thank you, Your Honor.
Thank you, Ms. Robert.
Thank you.
Mr. Brock?
Thank you, Your Honors.
And we'll give you an extra minute or so since she had a little extra time.
Thank you.
Before you get into what you want to respond to, let me ask you, or pose this question to you. Assuming Judge Ash has ruled that a lack of jurisdiction defense would not have been successful here, why is that not dispositive of your legal malpractice claim?
It would be dispositive if it's a correct ruling.
Okay.
Yeah.
So why would we not start out with that analysis?
You could decide that as the threshold issue.
What is that not the threshold issue?
Well, I think we analytically wanted to argue
Sure, I understand. It's a lot more fun that way.
in a way that makes sense analytically. But yeah, if as a matter of law, because personal jurisdiction is a legal question that this court has to decide to know. If, as a matter of law, there's no personal jurisdiction, or I'm sorry, there is personal jurisdiction over Brands in the underlying case, yeah, we wouldn't have a case. We wouldn't have a case. I agree with that.
Okay. And what factors did the court rely upon, and why is that in error?
Well, its general jurisdiction analysis was in error because it relied on a doing business analysis, which isn't the correct analysis. First Community Bank and Gordon v. Greenview out of Tennessee, both, which were law at the time that everything was happening in the underlying cases, clearly established the rules there for general jurisdiction, that doing business alone is not enough. You have to look at the entirety of the contacts with the state. And in First Community Bank, those contacts, the rating agencies in that case had dozens of people working in the state. They were making millions of dollars in this state. And if you look at it and go, gosh, that's a lot of doing business. But the court said, no, you have to look at the entirety of their contacts in the state versus nationwide and worldwide. And it said, those amounts, although appearing big, are a small percentage of their overall business. And what we've established here, likewise, brands, customers, and revenue out of Tennessee is less than 3%. And that's undisputed. So, and for...
Why is 3% the magic number, or what is the magic number?
Well, I'm not sure that there is a magic number, but you do have to look at the entirety of it. And if it's not the principal place of business or the place of incorporation, then you're into what the Supreme Court has called the exceptional case. And it's rare that an entity would be at home in somewhere other than their principal place of business or place of incorporation. And this is not the exceptional case. This 3% of business, there's no solicitation of business, there's no offices here, there's no real estate here. It's a very small part of their overall business. And under the U.S. Supreme Court cases and the Tennessee Supreme Court cases that view this, there's no general jurisdiction. And there wouldn't be specific jurisdiction either, because the contacts that brands had with the state of Tennessee did not relate to the underlying case or the underlying accident. There's no connection between them. And Judge Ash's ruling states that's undisputed. But then he said the driving history check that brands performed appeared to say that it was performed in Tennessee, which is incorrect. It was performed in Ohio for a Kentucky company. And then he said, well, it's quite foreseeable that somebody driving from Florida to Kentucky could get in an accident in Tennessee. Well, foreseeability has been rejected by the Tennessee Supreme Court and the U.S. Supreme Court as a factor for finding jurisdiction, because then you get into the whole stream of commerce thing, and that's been rejected. So there's no general jurisdiction, there's no specific jurisdiction as a matter of law under these facts. And that's, I would hope that that's the conclusion of this court. And then from there, do we have standing? Well, they're standing on a direct basis under the restatement 51 and Stinson and those cases. We have standing under the subrogation agreement, both contractually and equitably. And to hold otherwise would put these lawyers in a special class, just for themselves, a special class of protection. The insurance company would have no remedy. It would increase premiums because the insurance company, like in this case, would pay out, but not be able to, seek compensation from the ultimate wrongdoer. And that's what we've cited a lot of out-of-state cases that weigh these things and the public policy concerns, and they've all uniformly come down and said allowing subrogation is a stronger public policy than not allowing it. And so I see my time's up, but to conclude, they're standing on both direct action, both on a subrogation basis. There's no personal jurisdiction, both on a general jurisdiction basis or specific jurisdiction basis. And there are facts to support a claim for negligent misrepresentation, as we cited in the papers. So, any questions?
Hearing none, thank you, Mr. Bruck.
Thank you,
and
Justices.
Mr. Roberts, for your arguments. We'll take this matter under advisement. That concludes the afternoon docket.